in the matters of BlueCrest Capital Management and the Commissioners for Commercial Revenue and Customs and an appeal in Chancery and BlueCrest Capital Management.
Yes, Mr. Ballard.
Good morning. I appear for the Revenue with my then friends Ms. Laura Poots and James Kirby, Counsel, and my then friend Mrs. Hardy and Mr. Marr appear for the respondent taxpayer. I hope your lordships have a core bundle, a supplementary bundle, and an authorities bundle.
Yes, and we have read the decisions of the FTT and the UT, and we have read the Scuddon arguments.
I'm grateful. So I will still make my preliminary comments, although this will be familiar ground, I suspect, to your lordships. But I do want to go through it just to set out some terminology apart from anything else to make sure we're all talking about the same thing. We've got two appeals for the same taxpayer relating to the salaried members' rules, one by the Revenue, one by BlueCrest. Under the rules, where three conditions are met, a member of an LLP is taxed as an employee of the LLP rather than as a partner. I'm sure I will get it the wrong way round, but it's important for the revenue that the conditions are met and that all three conditions are met. The taxpayer wants to try and fail one of the conditions in order to avoid the application of the rules. So I say, I will almost certainly get that the wrong way around at least once, and I apologise in advance for that. The conditions, in short, are first condition A relating to profit sharing and earnings, condition B relating to influence on the affairs of the LLP, and condition C relating to capital contributions to the LLP. We're not worried about condition C, we are worried about conditions A and B in this appeal. In the Upper Tribunal, HMRC 1 in relation to condition A, and on condition B, HMRC 1 in relation to some members, but very broadly, the taxpayer 1 in relation to the more senior members. So we, HMRC, are the appellant in relation to those senior members. As we'll come on to, the taxpayer has a sort of conditional, contingent appeal in relation to some of the other members. One consequence of this...
I haven't picked that up. It's contingent, is it?
Well, I think that's a reasonable way to express it. It only arises...
That's how I read it.
If the revenue's construction argument on condition B is accepted, and then the taxpayer says, well, if we need to adopt a different approach to the construction of condition B, then we should revisit what was said in relation to the more junior members. I probably will use words like that, although some of the other members are senior, that they just have a different type of role. But labelling is a little bit tricky. Now, just to, I hope this is helpful, just to run through, we've got 5 skeletons, your lordships have 5 skeletons, because of the way things have evolved. There's the revenue's main skeleton in the original appeal, which is Appeal 2512, which covers HMRC's main case on condition B. That's the members in respect of whom the revenue lost below, which is to say, I'll come back to exactly what they are, but portfolio managers with capital allocations over $100 million and desk heads. So those are the more senior members. HMRC 1 in respect of the other members, so our main skeleton doesn't really deal with that. Then in response, we've got BlueCrest's main skeleton in 2512, which responds to the revenue's condition B argument and sets out BlueCrest's condition A argument. And then we have HMRC's supplementary skeleton in 2512, covering HMRC's position on condition A. Those are the first 3 skeletons. I'll call them our main skeleton, BlueCrest's main skeleton, and our supplementary skeleton. We've then got the skeleton in BlueCrest's cross-appeal, setting out that contingent point, which is just to say that if the revenue is correct on condition B, then the appeal should be remitted for reconsideration of the application of condition B to the other members. There's a little possible dispute over precisely which other members are affected by that. As we understand it, it doesn't affect the lower allocation portfolio managers, but does affect other classes of members who weren't otherwise covered by the revenues appeal. I think I'll come on to that sort of detail point maybe at the end when talking about disposal. And then finally, the fifth skeleton is our cross-appeal skeleton, just responding to the points on BlueCrest's cross-appeal. Now, in light of last year's encouragement from the courts to share the oral advocacy with junior counsel, where they've contributed to the skeleton arguments, which my juniors most certainly have, we're proposing to divide up the submissions as follows. I will open generally. Mr. Kirby will then make submissions on the partnership case law as part of the context for the construction and application of conditions A and B. Ms. Poots will make submissions on condition A, and then I will come back and deal with condition B and the question of disposal. By that I mean whether the court should, if it's with us, remake the decision or remiss it. And if it's remaking it, whether it can do that on a broad basis or whether it needs to get into the detail. I anticipate that the court won't be terribly interested in getting into the detail, but we have provided the materials in case I'm wrong on that.
And you and Ms. Hardy have agreed a timetable between you, have you?
We've agreed an order rather than a timetable. Right. In reply, we'll then, obviously, Mrs. Hardy will then make submissions to the taxpayer on everything, and then we'll reply in reverse order, as it were. So Mr. Kirby will reply on the partnership case law, Ms. Poots will reply on condition A, and I'll finish sweeping up condition B and disposal. Now, it may be that the court is sufficiently familiar with the facts that we don't need to go through them in detail. They're set out in the FTT decision and summarised in our main skeleton, beginning at paragraph 10 on page 25 of the core bundle, up to paragraph 20. It may just be worth adding. Would it help to go through those, or shall I take those as read?
Well, we've read the description in the FTT and the Upper Tribunal and in your skeleton. So.
Yes, I think I'm inclined to take it as read. I mean, but although it now, reading those documents probably gives the impression that the facts were agreed, and the court might wonder why we spent so long on them in evidence below, but they had to be explored in detail, and what the court has read is a proper distillation of that. On the primary facts, I don't think there's very much, if anything, between us.
I mean, I think what would be helpful is that at some point you took us to the LLP agreement.
Well, I can do that now. I was going to expand on this a little bit. So that's in the supplementary bundle at 44. I'll give you the reference there. Sorry? Starts at 13, sorry. So, obviously it was amended from time to time, but I think the parties are agreed that we can work from the version of the 10th of July 2013, which we have in the bundle. It's got the normal sort of unsurprising recitals and initial provisions. It's English law by clause 4. And then we get into the meat of it over the page. Well, we have the list of original members. And then the meat of it on page 21. I think, well, sorry, these are still members, but 23. I mean, I think for our purposes at this stage, we probably want to look at the governance provisions and the profit provisions, which are in
clause 14?
14. 10, yes. Sorry, we need to pick up something in clause 10 on the way through, which is the page 44. Sorry, page 46? 36. internal 36. Let's go to clause 14 while I remind myself. Management of the partnership is clause 14. I don't know whether it's helpful for me to read large parts of this. 14.1, we see that it's the board which has responsibility for day-to-day management and control of the business and the affairs of the partnership, and has the power and authority to do all things necessary to carry out the purposes of the partnership. And then there are meetings.
Excuse me, this is the court reporter. Could counsel please move closer to the microphone? I'm having terrible trouble hearing you. Thank you.
Sorry. Is that better?
Much clearer. Thank you.
Thank you. So we've got two microphones. One was too far away. Clause 14. Clause 14.1 is vesting the authority in the board. 14.2, membership of the board, which are the entities listed in the
You're dropping your voice, Mr. Valent. I wonder if you could speak up.
Yeah. 14.2 is membership of the board.
Yeah.
14.3 is the requirement for meetings. 14.4, the quorum. 14.5, attendance and voting. 14.6 provides the rights for the members. All or any members of the board may participate in the meeting of the board. That's just the board, not the members of the LLP. There's a conflict provision, 14.6. At the end of 14.6, 14.7 lists the board's powers, and 14.8 gives us the requirement for there to be a vote in certain circumstances. And those are 14.8a, any material change to the general nature of the business, creation, renewal or extension of any borrowings by the partnership, if that means that the borrowings exceed in aggregate 25 million, the making of any loan by the partnership, again, leading to an excess of 25 million, the giving of guarantees, the issue of debenture or loan stock. I think we then, having noted that those are the circumstances in which the members of the LLP have a right to vote and the board has to listen to the vote, I think we need to go to Schedule 3, which sets out the way that vote operates. It's page 67 of the bundle. Meetings of members. One, the board's obliged to convene the meeting. I don't think we need to worry about the provisions for notice and so on and so forth. If we go down to, well, 8, all or any of the members may participate in the meeting by means of any communication, so they can be physically or remotely present. 9, so where there has to be a members' vote, 9 tells you how that happens. A resolution put to a vote of any members' meeting should be decided on a show of hands, unless a poll is demanded by any one member before any such vote. At any members' meeting, every member who is present in person or by proxy shall, on a show of hands, have one vote, and every member present in person or proxy shall, on a poll, have one vote for each 1% of capital profits and losses that this is entitled to from time to time, pursuant to clause 10.6, which we'll go back to 10.6. And to the extent that a member does not have an entitlement to capital profits and capital losses, then such member shall have one vote on a poll. Save as required by law, at any meeting of the members, a decision shall be taken by a simple majority of the total voting rights of members who vote in person or by proxy on any such decision at such meetings. If we go back to 10.6, which is the bit I failed to pull out previously because I couldn't find the page 40. Any capital profits realised or capital losses realised realised in respect of any financial year of the partnership, in respect of any of the assets of the partnership, including any goodwill, etc., shall be allocated to, and then you see where it's crossed out at the end, though, it says to BCUKL, i.e. the corporate member. So the capital is allocated to the corporate member, which means that the corporate member has 100 votes, and each individual member, not having any capital entitlement, has 1 vote. Or potentially has 1 vote if they're attending and voting at the meeting. Now, the relevant time, I mean, the numbers fluctuate slightly, but from the FTT decision, for reference, I don't think I need to send it up. There are 82 members, paragraphs 36, 40 and 42, 16 infrastructure members, 48 portfolio managers and desk heads, and 18 other front office members. So, very roughly, we had up to 182 votes in play, and roughly each individual partner would have had a vote worth about 0.5%, as it were. I think I went too quickly over 14.1 as well. I've talked about the vote. So this is where the board has to have a vote in order to endorse certain transactions. More generally, in 14.1, the board has to consult the membership. As we're going through 14, so 14.1 includes in the second sentence that duty to consult. 14.6, 14.7 includes the, and 14.8 covers the meetings.
Sorry, where are you now? 14.8.
Sorry, 14.8, yes.
Yeah.
That's on the meeting. 14.11 gives us the executive committee. This is referred to in our skeleton at paragraph 20b.
Yeah.
That's the executive committee which deals with the day-to-day operation of the LLP. I think if I mean I could do the provisions on profit now, but it might be easier to focus on governance for the moment and come back to profit in relation to condition A. Is that? Yeah. So what we have is a board with overall high-level control of the LLP, which has an obligation to consult the members in general and to call a vote on certain important issues. On that vote, the individual members have a vote, but it's a very diluted vote, partly because there are so many of them, and partly because the corporate member has 100 votes by virtue of his entitlement to capital, as opposed to 1 vote per individual member as of right.
I'm sorry, I must have missed something. Where is it we find the 100 votes allocated to the corporate member?
It's because in clause in the schedule, paragraph 9,
Yeah.
Page 67, the votes are by reference to capital. And then we see from clause 10.6 that the corporate member has the capital entitlement. It's by reference to capital, but if you don't have any capital, you have one vote.
I'm sorry, I'm being very slow. How does that translate into 100 votes for the member that does have the capital?
The corporate has 100% of the capital, so it gets 100 votes by virtue of its.
Oh, I see.
Whereas the members are limited to the one vote per person attending. Under the second part of that, so it's page 68. Clause paragraph 9 of Schedule 3.
Yeah.
So those are the formal rights enjoyed by members in their capacity as members. There's also the Executive Committee and various subcommittees with more or less formal roles in the governance, and the subcommittees obviously report to EXCO. In the skeleton 22, we said the original EXCO until November 2016 were just Mr. Cox, Mr. Teheldre, Mr. Weir and Mr. Moss, and the Revenue accepted that those 4 individuals had significant influence. In November 2016, a further 15 individual members were added to EXCO. Those were members who had attended and spoken at EXCO, but hadn't been members of EXCO. And the Revenue would say that it appeared to the Revenue to be a response to the Revenue attaching importance to EXCO that they were added to EXCO. And the Revenue does not accept that those 15 additional members have significant influence by virtue of their membership of EXCO. So what I was going to turn to next, if that's enough on governance in light of what's said in the decisions, I was going to look at the different categories of member. It's important to keep those separate because the courts have reached different, the tribunals have reached different conclusions in relation to different categories of member.
Yes. Sorry, just before you leave clause 14, and somewhere in one of your skeletons, I thought I saw a reference to reliance being placed on 14.16, provision of information to members in order to help them prepare and submit their tax returns. Is that something you place any reliance on, or have I misunderstood that?
It's 14.16. I think our skeleton actually has that wrong. I think it says 17 for some reason. It's 14.16.
Yeah.
It's not something we would place any reliance
on. In that case, I thought it was. I thought there was perhaps a suggestion this meant the members only had very limited rights to information.
Oh, maybe we do. Yes. Okay, sorry. We placed it on reliance on it in the negative, in that they don't have more, they don't have greater rights than that. We don't place reliance on it positively, as it were. But yes, I mean, the fact that it's limited to that is significant.
Well, it may or may not. I would have thought, we may come on to this later, I would have thought under the default rules in the LLP regulations, you would have had a prima facie right as a member to look at any documents, wouldn't you?
Well, I think we will come back to
okay, so if you're going to come back to this, that's fine.
This is something my learned genius is going to deal with, that it's quite striking that the LLP regulations are excluded and replaced. And in some cases, the rights, as your Lordship points out, are more limited than they would be by default. Sorry, I'm just checking I've got that. I've summarised the submission that we'll come on to.
Okay, so I haven't appreciated they were excluded in toto.
Well, yes, I mean, they're as it were replaced, I think.
What does that? What excludes them?
Have we got the clause? We've got it. Sorry? 25.8 in the same...
25.8?
In this document, yeah. So it's page 64 of the bundle. None of the default provisions set out in Regulations 7 and 8 of the LLP Partnership Regulations 2001, or any other such provision as is mentioned in section 5.1b of the Act, shall apply to the partnership or the mutual rights and duties of the members. I think
Yeah, no, well, thank you. I hadn't picked that point up.
it probably is much better for my learned friend to expand on what that means and the contents of those duties, which he's going to do in due course. So,
Right. We're going on to different categories of member now.
well, I was going to look at the different categories of member. But I listed in the skeleton, beginning at 23. Most of the tribunal time was spent on portfolio managers, who are the members responsible for managing a particular portfolio of positions. These portfolio managers had varying capital allocations, which, at the risk of oversimplifying, relates to the risk to which they can expose the partnership, rather than purely or simply assets under management. The tribunals have found that portfolio managers with allocations of more than $100 million had influence over the affairs of the LLP and therefore did not meet condition B. But portfolio managers with lower allocations did not have such influence and did not meet condition B. Now, the portfolio managers were managed by desk heads. Some of those desk heads were portfolio managers in their own right, some weren't. The tribunals have found that the desk heads had influence and did not meet condition B, whether or not they had their own capital allocation. So the portfolio managers with over $100 million allocations, plus the desk heads, are the more senior members, as I will find myself saying, who did not meet condition B, and therefore, in respect of whom BlueCrest won below.
Is it common ground that there are some desk heads who don't have any funds under management of their own?
Yes.
Because at some point in some of the respondent skeletons, I think it's said that that is not the case, and that they all, that they all had portfolios. But I think your position is there are at least some who don't.
I hadn't understood that to be contentious anymore, at least.
Okay, if it's not contentious, that's fine. I just want. I mean, it may not matter, but
there might be one, I think, but we'll check that.
Okay, thank you.
Oh, okay. We'd been proceeding on the basis that it wasn't an empty set, but that it doesn't really matter since we'll come on to it. I suppose it might matter if the tribunal found that it was only by virtue of having a capital allocation or the court found that it was only by virtue of a capital allocation, but that would be an odd and unexpected result from everyone's point of view, I suspect. So it may be that most of the desk heads, well, I'm sure it is that most of the desk heads also have a capital allocation and will have a capital allocation over 100 million, I imagine, by virtue of their seniority. Then we come on to the infrastructure members, who provide various support services to the LLP and the wider group. Pausing there, I should just make this point, which I'm sure the court has, that the LLP did two things broadly. It managed investments, or it took positions, but it also provided support services to other members of the BlueCrest group. It had two business streams, two income streams. And the infrastructure members would have both provided the support services to the LLP and provided the services pursuant to that other business stream. Some of those members were senior, including members of the original EXCO, and some were heads of department. Nonetheless, apart from the members of the original EXCO, the tribunals below at the FTT found and the Upper Tribunal accepted that those other infrastructure members did not have significant influence and therefore met condition B. Finally, there are front office members and non-portfolio managers. There really wasn't very much evidence on that, and the tribunal found that in light of that, those members didn't have influence and therefore met condition B. Just on terminology, we've used other members to cover members other than high allocation portfolio managers and desk heads. So we've used it to cover lower allocation portfolio managers, infrastructure members as described by the FTT, and other front office members. BlueCrest has used the term infrastructure members to cover what I've just described as other members. We would suggest that our terminology is more helpful because it's the terminology used by the FTT, and in any event, to use the term infrastructure members to include non-infrastructure members risks confusion. So we will stick to using other members to describe the category I've just outlined of lower allocation portfolio managers, infrastructure members, and other front office members. And we'd encourage the court respectfully to do the same. Now, we may already have covered this, but just to be clear on where we are on the procedure, HMRC are appellants in relation to the 100 million plus portfolio managers and desk heads on the basis that they did not have the requisite influence over the affairs of the LLP, and therefore met condition B as well as condition A. And in response to that, FTT says, BlueCrest says that the tribunals were right about influence, i.e. that those members did have influence, and then as a respondent's notice point, that the tribunals should also have found that they failed to meet condition A on the basis that their remuneration was linked to firm profitability, varied with firm profitability, so that they failed to meet condition A. We obviously reply on that to say, no, the FTT was right on condition A. And then in response, we've got BlueCrest's appeal on the other members, which is the contingent appeal, saying, well, if the revenue is right on condition B, we need to know what the court says that condition means, and then ask the FTT to reassess in light of whatever the court says condition B means. I've said, our understanding is that BlueCrest's appeal can't cover portfolio managers with allocations below 100 million. There wasn't a positive case advanced below to that effect. And it's not set out currently. But it's not absolutely clear. It's not expressly disavowed. So we may need to come back to that. But our position is that there shouldn't be, even if everything, as it were, is remitted to the FTT for reconsideration, that reconsideration should not cover sub 100 million portfolio managers. So finally on the facts at this stage, just as a note, our skeleton at 26 sets out what we say are the key points on influence, and our supplementary skeleton in the main appeal at 5 to 7 sets out what we say are the main facts on calculation of pay for portfolio managers.
Sorry, which paragraph of the supplementary?
5 to 7.
5 to 7. Yep.
So, just to cover the legal framework very quickly, as your lordships will be fully aware, LLPs are legal persons, legal entities, governed by a distinct statutory regime that are treated as tax transparent, or transparent for most tax purposes. I don't think I need to turn it up But we have the basic income tax provision, the Income Tax, Trading and Other Income Act 2005 at section 683. What that means is that generally members of LLPs are liable to income tax on their share of the underlying profits of an LLP. With effect from April 2014, however, the salaried members rules deem members of LLPs to be employees for tax purposes if the three conditions are met. And this is in the authorities bundle at tab 14 following. Sorry. So 863A is on page 30 of the authorities bundle. Again, given that your lordships have read the decisions below, I don't think we need to spend very long on reading through them, but it's probably helpful to turn them up for reference. 863A is the main rule. Subsection 2 applies at any time when conditions A to C below are met in the case of an individual who's a member of an LLP. And the effect in 863A sub 2 is that for the purpose of the Income Tax Act, M, the member, is to be treated as being employed by the LLP under a contract of service instead of being a member of the partnership, and accordingly, M's rights and duties as a member of the LLP are to be treated as rights and duties under that contract of service. And that needs to be read with 863G. 863G was an issue, but my understanding is that it's no longer an issue, but I'll turn this up since we're there.
Although nobody's mentioned it, I was wondering how that fits with section 4, subsection 4 of the Limited Liabilities Partnership Act.
I think that's probably the point. Is that the point covered in the...
Right.
Yeah. It's covered in one of the cases as it happens, isn't it? I think it was a decision of Mr. Justice Warren. Is that the one? Yeah. If I may, if I leave that to be covered with the LLP context, but it is an issue. If I may, condition A is set out in section 863B. Yes. On page 43. I think, well, this is to do with remuneration. And there's a process set out in sub 3. We identified the relevant period, which was held by the FTT to be the accounting period, so it's an annual exercise. I don't think there's any appeal on that point, so we are looking at this annually. That's step 1, identify the relevant period. Step 2, we then ask, condition A is met if at the relevant time, that's say the beginning of each accounting period, it's reasonable to expect that at least 80% of the total amount paid by the LLP in respect of the relevant member's performance during the relevant period of services for the partnership in M's capacity as a member of the partnership will be disguised salary. And that's obviously covering the possibility that someone has more than one relevant, or more than one relationship with the LLP, but this is only looking at the membership reward, as it were. An amount within the total amount is disguised salary if it's fixed, lim A, variable but varied without reference to the overall amount of the profits or losses of the LLP, lim B, or is not in practice affected by the overall amount of these profits or losses, lim C. So we say that what that's seeking to do is draw a line between someone whose pay is like partner's profit share and someone whose pay is like an employee's remuneration, which will either be fixed or will vary in relation by reference to something other than the firm's profits, in effect. I don't want to preempt what Malone Jr. is going to say on that, but that's the thrust of it. Condition B in 863C is about influence. Condition B is that the mutual rights and duties of the members of the LLP and of the partnership and its members do not give the relevant member significant influence over the affairs of the partnership. As your lordships will be aware, we say that the legal question, the first legal question on condition B, is what is meant by significant influence over the affairs of the partnership. We say it's not such a simple phrase that one can just say, oh, well, you read it and you know what it means and you just have to apply it to the facts.
Isn't the first question what does the mutual rights and duties mean?
That is a question, although I think there's not much between the parties on that. We say the starting point for that is the LLP agreement, but we're happy to accept that one has to, taking a realistic view, look a little bit wider than that and take account of what actually happens to find what those rights and duties are.
Well, that's really going beyond the wording, isn't it? I mean, the wording seems to be explicit that you only look at the mutual rights and duties, both horizontally and vertically, to see whether they give significant influence. I mean, that's what Parliament has said. You may not like it.
Oh, well, I don't think we wouldn't mind it in the context of this appeal. Well, if it's a concession on the revenues part, so be it. But
it's a. I mean, it struck me as rather a curiosity of this drafting that the whole thing seems to be tied to mutual rights and duties. Whereas if it had just been a question of looking at the question whether there was significant influence over the affairs, you wouldn't need any of this stuff about mutual rights and duties. So what's it adding?
Oh, well, we accept that the starting point is the LLP agreement plus the statutory regime. That's certainly the starting point. We're accepting that one can go a little bit wider than that, and one should go a little bit wider than that to take account of how they're operated in practice.
Well, is it a question of what is the source of the mutual rights and duties? So, an obvious source, and one would have thought the primary source will be the LLP agreement. But if I have understood you correctly, you're accepting that one cannot postulate a priori the possibility of other sources of mutual rights and duties.
Yes, and so we're happy that there's a possibility, at least, that there should be someone like a shadow director who, although not having a formal role in the governance of the LLP, nonetheless has an established de facto role in the governance of the LLP.
But why would such a person have rights and duties? I mean, I can understand that there may be other sources of rights and duties, but why would someone who's operating in a shadow capacity have any rights or duties?
We find it quite hard. We have an example in this case of Mr. Platt at the very top, whose influence is pervasive. And for us to say that he didn't have any rights in relation to the LLP, we thought would be unrealistic.
Where do those rights come from?
Yes, I'm not sure I can point to the legal document showing those rights, but I'm sure I can't. I mean, he is a member of some of the bodies, but he isn't given that his membership of those bodies doesn't fully account for the extent of his influence.
And what are his duties?
Well, I suppose his duties are mainly to exercise his rights responsibly, rather than being, they're not set out, so I would struggle to say precisely what the duties were, other than, as I say, exercising that influence responsibly. he is in an odd position, and your lordships will have seen that in the decision, that he is effectively the main customer of the LLP for much of the period under appeal, because he is by far the largest investor in the LLP, as well as sitting at the top of the structure. He is both the customer, I need to be careful exactly how I express it, but both the customer and the ultimate investment manager.
And just to be clear, the funds he invests are his own personal property from whenever the funds were closed to external investment.
Well,
Right?
not entirely his, but he is by far the largest beneficiary or investor. There's also Andrew Dodd, but he is by far the largest investor.
Yeah.
As I think investor is a reasonable way to put it, although the way that the positions are taken, it's not as simple as buying and selling assets. They're taking derivative positions on various markets and what have you. Yes, but if we were saying you only have to look at the LLP agreement, then I accept in a way it would be a much simpler argument for us, since we would simply say, look at the provisions of the LLP agreement that we've just been looking at.
As I was exploring with you earlier, there could be other sources of rights and duties. I mean, there might, for example, be an oral agreement alongside the LL agreement, which would give rise to rights and duties.
Well, none's been suggested. None's been suggested by the LLP or its members in this case. They've proceeded on the basis of their evidences that the formal structures are ultimately respected as set out in the agreement, even if, for practical reasons, decisions are sometimes taken and then ratified later. But the evidence is that they respected the formal structure.
Well, I was wondering whether the approach in domestic law laid down by the secret hotels case is the way to approach the LLP agreement.
Okay.
It was distinguished in Uber because of the special policy considerations affecting employment law.
Well, sure, may I come back to that? I mean, as I say, our primary case anyway, and it may be that we should formulate a proper secondary case to address the lordship's feelings on this. Our primary case is that although one starts with the LLP agreement, and I'd accept any other relevant agreement, I'd accept that, but in this case, the LLP agreement, but we would be happy to look at what actually happens and the way in which that agreement is actually given effect, so that if there are members who, in fact, routinely wield influence by virtue of their status as member, that should be taken into account. We'd be happy to accept that slight softening of the
How does that fit with the statutory language?
Well,
It's the mutual rights and duties that must give them significant influence. So if they exert influence without having any mutual rights and duties, how does that fit?
well, I think we're saying that that is a right, because in practice, one sees them influencing decisions. It's a broadening or a purposive construction of rights and duties to encompass what happens in regular practice. I suppose part of the worry is that taking a very strict approach to it would lead to, would be criticised as unrealistic on the part of the revenue. But we do accept, we would say that the starting point at least is the LLP agreement. We're not abandoning the LLP agreement entirely. We're not saying it's purely a matter of pragmatism and that one is only looking at actual influence. We are looking at influence qua member and just accepting a softening of that to take account of practicalities.
But the problem is, as soon as you move away from a focus on mutual rights and duties, where do you stop?
Well,
Because you seem to end up with a test of, does this person have significant influence, which is not the statutory language.
I accept that, and we would say you certainly exclude influence exercised in another capacity. So if we were looking at, it may be that one should exclude Mr. Platt's influence on that basis, but if one were looking at the influence a customer had on the affairs of the partnership, for example, one would not be looking at that influence.
Because they're not members.
Well, they may also be a member, but if they're a member and a customer, one wouldn't be looking at their membership, their influence qua customer, only qua partner. So that would certainly be one limit. And we would, I mean, this does come on to maybe what sort of influence. We would say that we're not, even if this would be described as influence, it wouldn't be influence deriving from mutual rights and duties. So the possibility that someone could make a catastrophic mistake, we would say, which might affect the partnership, we would say that isn't something that derives from their mutual rights and duties. That's something separate. That's a separate source of thing.
And on the face of it, rights and duties is legal language, isn't it? I mean, the right is
Yes.
something you have an entitlement to do, and a duty is something you have an obligation to do.
Yes.
And Parliament, for whatever reason, has chosen to frame this test not just in terms of significant influence, but only a certain type of significant influence. And that is one which derives from the rights and duties.
Yes.
That's a language we have to interpret and apply, and it seems at the moment to be unambiguous on that point.
Well, I mean, I shouldn't perhaps be resisting this. It gives us the right result in this case, but I think our position formally, and our primary position, is that one can look a little bit wider to how the partnership is governed in practice, and that where people, by virtue of their membership rights or their status as members, exercise influence above and beyond that laid down by the strict legal position, one should take that into account.
Well, I suppose you have to cater for the possibility that somebody drafts an LLP agreement which on its face gives everybody significant influence, but in practice it's never operated.
Well, it certainly needs to go both ways. So yes, we would need to accept that if, and one of our points is that it's quite hard to see if you had 200 members, all of whom were on the face of it given equal rights and duties, we would say it's quite hard to see how each of 200 people could have significant influence, just numeric.
Then you fall back on the other conditions.
Well, no, because they may meet fail to meet the other conditions. We may need condition B.
It's a kind of a quantum test. It's got to be significant. I mean, that's not defined, but obviously it must mean more than insubstantial.
Well, that's our. Well, I mean, we were shot down in the Upper Tribunal at this point, but we say that it's not just influence; it's significant influence, and significant influence, we would say, means something. And whatever that number is, it's more than 1 out of 1 out of 2 in terms of the votes. To reach a conclusion that 82 people have significant influence, we would say is surprising. I can't say it's more than that. I can't say it's more than an indicator of how it should be construed. I can't say it's impossible, but I can say it is an indicator.
On one interpretation, significant just means not insignificant, so it's a very low threshold, just something that signifies.
Well,
can't be dismissed as sort of almost immaterial.
Well, I accept
in which case,
that.
80 people would perfectly well have significant influence.
Well, the problem with that approach would be one would ask, well, why has the drafter of this legislation included the word significant if all they meant was not insignificant, when insignificant influence would inevitably be ignored anyway. A taxing statute is not, and the argument that a taxing statute should take account of insignificant influence strikes me as an impossible one in the current, the current authorities. So we say that that qualification of influence must add something more than merely not insignificant. That's where we get to the idea that you need to have, you've got insignificant influence, which can be ignored on any view. You've got, as it were, mere influence, unqualified influence, and we would say you've actually got a third category of significant influence, which is greater than mere influence. I mean, it's not the biggest point in our arsenal, but we would say that giving effect to each word means that the court does need to attach some weight to the word significant, as well as merely noting that it must mean not insignificant, which would be ignored in any event, influence.
And plainly, we have to construe the phrase as a whole.
Yes.
And on any view, we
Yes.
mustn't look at it in blinkers or
No,
in isolation. But having said that, I mean, the statutory language is the starting point, and if it's not ambiguous, is usually the finishing point. And it's very simple language, and it's not as though there are any great complications.
Well, it's simple in one sense.
Deceptively so, you may think.
we would say that the court, when construing it, certainly needs to take account of what it is intended to achieve. And that background can be seen both, and we'll come back to it, both from the relevant technical note, but also from the legislation itself. One can see that this is intended to draw a line between LLP members who are like partners and LLP members who are like employees. We don't say that the three conditions, that one can ignore the conditions and simply ask a general question, are they like employees? No, each of the conditions is a proxy for a facet of the relationship between a partnership and its members, as it were, or between an entity and its employees, as it were. But each of them has to be construed, each of the conditions has to be construed in that context. So when, and this is the core of our case really, on condition B, when we're asking what are these mutual rights and duties of the members that give rise to give significant influence over the affairs of the partnership, what we're asking in effect is the member in the position of a partner in terms of their influence over the affairs of the LLP, as opposed to being in the position of an employee. And that's where we get on to the arguments about the, as it were, the level or the type of influence. We say it's high-level managerial influence, not day-to-day operational influence or impact. I mean, I don't want to get too far down that because that's our condition B argument. But we do, so although the language in a sense is simple, it's only one sentence, we accept it has to be construed as a whole. And when we make submissions focusing on one aspect of it, we're not meaning to forget or ask the court to forget that the ultimate exercise is construing the whole phrase. We do say that that context is awfully important, and maybe means that the exercise is a little less simple than first appear.
But I mean, you can't really tell whether something is, somebody has significant influence unless you ask over what?
Well, no, over the affairs that we need to know what the affairs of the partnership are as well, what it means by that. And
but that's why chopping up this phrase is not necessarily terribly helpful.
No, I completely accept that ultimately one can't chop it up, and we're not meaning to do that. We are focusing on different aspects of it one at a time, and then bringing it all back together. Yeah. Or perhaps we're starting with the whole, see it, what's it there for? It's there to draw a line between, as it were, quasi-partners and quasi-employees. How does it do that? It does that by the language we've got there. Looking at each of those words, they are each of, or many of them, potentially ambiguous. does significant add anything to influence is one question. Does influence mean effect, or does it mean bending to your will, something like that? Affairs of the partnership, does that mean high level, the sort of management and control issue that one might be considering for tax residents, or does it mean nitty gritty day to day, everything the partnership does? So there are questions in relation to the various words which we examine separately, whilst accepting obviously that the ultimate task is to construe the condition B as a whole in the context of the salary members' rules as a whole. So absolutely, we don't want to lose track of the wood for the trees, or the trees for the wood. We have to strike a balance. Shall I just finish the summary, and then we will be coming back to condition B?
Yes, by all means.
Condition C that we don't need to worry about is to do with capital. That's on page 46. And then if we skip on to the end, we've got 863G, the end of the tab, on page 52. We've got an anti-avoidance provision that was a live issue, but is not now a live issue. All of that is covered in our skeleton, in the main skeleton at 27 onwards, and in the supplementary skeleton at 8 onwards. I was going to cover the decisions below. I think we've probably effectively done that as we go, as we've gone along. Obviously, the FTT held that all the members met condition A on the basis that their salaries were either variable but without reference to the overall profits, or were not in practice affected by the overall profits. So they met, they fell within limb B of condition A, and if they didn't, they fell within limb C. Then the friend will deal with that in more detail in due course. And then the Upper Tribunal upheld that. In relation to condition B, the FTT considered that significant influence was not limited to the sort of managerial influence that the revenue was arguing for. So it was any sort of influence, and also that the influence was not limited to being the affairs of the partnership generally, but could be over a single aspect of the partnership's affairs. That's the main skeleton, set out in the main skeleton at 31. And the result of that approach is that the FTT held that the portfolio managers with allocations over $100 million and the desk heads had significant influence. The other members did not. The Upper Tribunal essentially endorsed that approach. On the Upper Tribunal, I think worth saying now, your Lordships will have read paragraphs 161 to 163 in the Upper Tribunal decision, which say that the revenue is wrong, or is effectively trying to dress up factual arguments as legal arguments. That's 161 to 163. It's begins on page 159 of the core bundle. We've tried to rectify it now, so we'll try to avoid the same confusion in our appeal here. Our primary case is that the tribunals adopted the wrong approach to the construction of condition B, and that having applied the wrong construction, they then inevitably misapplied it and reached the wrong conclusion on its application.
But your basic point, I think, is that what the Upper Tribunal says in paragraph 87 is just wrong.
87.
87.
Yes. I mean, that's certainly a very significant point, and that's where the fine line and grind business comes in, that what the FTT focused on is what people did, rather than, in any sense, the rights and duties they enjoyed. But as a question of whether we're attacking as it were, the legal conclusions or the factual findings, I just want to emphasise that it is very much a legal point, first and foremost, as to what condition B means. And respectfully, the Upper Tribunal was wrong to dismiss, as it does in 161 to 163, our arguments as being an attempt to reopen the facts. The reopening of the facts is a consequence of the legal argument.
Yeah.
So that's decisions below. I think we've already, again, we've covered the issues. I don't think I need to go through those again, but if it helps just for taking a note, shall I list what I think are the 5, or depending how you count them, 6 issues? The first issue, we say, is the construction of condition B. So we say that condition B is looking at the influence that a member enjoys as such over the business of the partnership generally at a high level. So it's board type influence, as it were. Now, and that's putting in one simple, probably oversimple statement, all the issues around the construction of condition B, which I appreciate include your lordship's concerns that we're being too, we're wrong to take account of the factual position outside the strict mutual rights and duties of the members. That's all tied up in what we would say is a first legal question over what condition B is looking at. Now, if your lordships were with the revenue on that, there'd be a second, we'd come to an issue about what should be done. Should the court remake the decision? And if so, should it remake it on the short basis that the FTT clearly didn't find that any of the members had that sort of influence? Or does it need to does the court need to get into the detail of the decisions? We say there is sufficient material before the court for it to do that, but as I said in the beginning, I'm frankly not expecting your lordships to be terribly attracted by that detailed analysis. So the third alternative, the alternative to remaking on either basis, would be a remitter. There's perhaps a subsidiary issue to that, which is whether the reappraisal includes the sub 100 million portfolio managers and so on. Then so the first 2 issues, construction and application of condition B in effect. The third issue is the construction of condition A. And in particular, whether it's correct that limb B of condition A required a closer link between reward and LLP profit than the LLP profit acting as an ultimate cap on the level of reward. So the third issue is limb B of condition A. Fourth issue is if not, effectively, is whether it was nonetheless reasonable to assume the profits would be varied without reference to overall profits. We say that's an issue raised on BlueCrest's, in the main appeal by BlueCrest on condition A. We say that although that is technically an issue, the FTT made a finding of fact to the effect that it was reasonable to make that assumption, and BlueCrest can't dislodge that finding. So those are 2 aspects of condition A, limb B, and then the 5th issue is condition B, limb C. What's meant by that?
Sorry, what's the 5th issue?
Sorry?
What is the 5th issue?
The 5th issue is condition A, limb C.
A, limb C.
Whether in practice
Right.
the amounts were varied, etc. And And then the following points we say are not an issue. First, the anti-avoidance provision. And secondly, as I've already said, portfolio managers with allocations below 100 million. I've only got a little bit left at a general level. Again, most of it I think we probably covered in discussion. And we're on paragraph 35 of the skeleton. This is the task, really, for the Court on construction is to construe the legislation purposefully, whether it applies to facts viewed realistically. Paragraph 35 of our main skeleton, where we cite Uber and Rossendale. I don't know whether we need to go to those in detail. I doubt it, but they are available in the bundle. What's not in the bundle, but can be made available, is last week's decision by the Supreme Court in Cobalt Data Centre, which also covers Ramsey-type arguments for reference, paragraph 70 to 107 of that decision. If it would assist the court, we can provide copies. We say it doesn't really perfectly sound decision on those, perfectly sound comments on those, but doesn't advance the law beyond where we'd already reached on Ramsey.
It was interesting there the Supreme Court took the policy from a Treasury press release.
Well, what I was going to say is the one point that might be of interest is that the policy, normally, I anyway would say that when we're looking for the purpose of the legislation, we start by looking in the legislation. And I accept that Cobalt is an example of looking outside the legislation. And to an extent we're doing that here, because we're referring to technical notes and so on and so forth. So to that extent it is a helpful example for the revenue. The reason I say it's not, as it were, game-changing, is that actually we say the purpose of this legislation is very evident on the face of it, that it's to draw this line between quasi-partners and quasi-employees, and that one doesn't really need to look at the technical notes in order to derive that. So with assist, we can certainly provide copies of Cobalt, and luckily one doesn't need to read the whole thing in order to see what the Supreme Court does in relation to Ramsey and Rossendale, or in fact in that case it's BMBF and Arrowtown.
Sorry, I haven't got a note of the name of this case. Did you say Cobalt?
Sorry, yes, Cobalt, C-O-B-A-T, Data Centre.
Cobalt, yeah. Thank you. Oh, yes, sorry.
Yeah, so 2024 UKSC 40,
yeah,
beginning at paragraph 70. Would it be, we can easily send through a PDF of that if it would be of assistance.
Well, look it up on their website or whenever.
Well,
could you go some of the paragraphs we need to concentrate on? You actually already said 70 and
70 to 107.
70 to 107,
So,
thank you.
I mean, as my lord has already said, they look at the technical materials, the pre-statutory materials, to help decide between what they say are two plausible constructions and come down on the revenue side, whereas the Court of Appeal had come down on the taxpayer side. And obviously, the Lordship's far more familiar with the Court of Appeal's approach, which goes into the contractual materials.
Yes, well, I thought I was just interpreting the straightforward words of the Act.
Well,
and I was wrong.
People always do. And then, but even with these cases that could go either way, once it gets to the Supreme Court, it turns out they were right. Yes, I probably wouldn't even mention it, frankly, if it wasn't so recent, and therefore probably appropriate to at least remind the court of its existence. Now, the reason I'm labouring that is the passage in the Upper Tribunal that I've already referred to. There are various points where they say it's simply a matter of applying the words of the statute. Obviously, on one level, that's true. That is the start and the end of it. But in the middle, we say one does have to take account of context and purpose.
Plus the obvious point, the meaning of the statute properly construed is a pure question of law. So there's no
Yes.
question of that being off limits.
Well,
And that's the whole point. The whole point of the exercise.
yes, and sometimes when one thinks the answer is simple, that's the worst possible warning sign that something's gone wrong. Anyway, so that's why I'm mentioning that here. Now, the context, I've already said, we see that the context is to draw this line. If we need it, that is picked up in the technical guidance in the authorities bundle, tab 43, page, I think we can go straight to page 701.
So the timeline of all this is that the consultation document was published in May 2013.
Yes.
December 2013 was the response to the consultation.
Yes.
That said at paragraph 2.10 that there was a technical note published alongside. That's not the technical note that we've got. The
Right.
technical note that we've got was the 21st of February 2014. If I've understood correctly, sometime I think in March 2014 there was a resolution to bring these provisions into force under the Provisional Collection of Taxes Act,
Yes.
and they were finally enacted, I think on the 7th of July,
But with effect from,
with effect from the 6th.
yes.
So this technical note was at least available at the time the legislation was passed.
Yes. This is the revised technical note that we've got in the bundle. I can't, I'm afraid, tell your lordships what the revisions were offhand, although if it would be a sort of assistance, we could no doubt dig out the original version and flag up the changes. But I think for present purposes, it's sufficient to work from the revised version. And if anyone had questions about the intended operation, I need to be a bit careful because there are judicial review proceedings floating around, but obviously this guidance would have been available to anyone who was looking at the legislation before it was enacted.
Yeah.
And what I was going to point to just really is reinforcing what I say is obvious from the legislation themselves is page 701, heading 1.7, paragraph 29. A common sense approach to applying the conditions.
Right, where are you? Page
Sorry, page 701.
701.
Bundle page 701, which is document internal page 7.
Yeah.
The three salaried member conditions are intended collectively to encapsulate what it means to be operating in a typical partnership. Some of the tests will be more or less appropriate for particular LLPs, but it's only if all three conditions are met that the individual will be treated as a salaried member, with income tax and NIC's treatment then applying as it would to an ordinary employee. So that's the point. It's intended collectively to encapsulate what it means to be operating in a typical partnership. We say that is effectively saying that one's trying to draw a line between two types.
And condition B is dealt with in paragraph 22.
Yes, I'll come back to this a little bit more later on the specifics. But I thought at this point it might be useful to expand on the general partnership background, or rather to ask my learned junior to expand on the general partnership background, and then to hand over to Ms. Poots to cover condition A. Unless there's anything else at this stage on those high-level points, I will sit down.
Yes, Mr. Kirby.
I'm going to, as my learned friend said, address your lordships on the partnership law background because of its importance as a context for understanding the salaried members' rules.
Excuse me, it's the court reporter again. Could counsel please move much closer to the microphone? Thank you.
I think it's not that microphone.
Is that better?
That's much better. Thank you.
The starting point for the law on salaried partners in traditional partnerships is the case of Steekel and Ellis, with which I'm sure your lordships are familiar. It's page 84
Yeah.
of the authorities bundle. The facts were Mr. Ellis was the sole surviving partner of an old partnership. He then takes on someone described as a salaried partner who receives a fixed salary, whereas the old partner, Mr. Ellis, is entitled to all the profits, and makes the only capital contribution and bears all the losses. A dispute arose as to whether there was a true partnership or not, and Mr. Justice McGarry holds that there was. Could I take you first to page 87 of the authorities bundle? Within the decision, letter F was helpful finding, which is the first sentence, not particularly important. He says that the partner is being held out on the firm's note paper as a partner. That's what you would expect for any salaried partner, whether employed or not. But the second sentence is more important. It says he also acted as a partner within the firm. He doesn't spell out there what he means by that, Mr. Justice McGarry, but in my submission it means participating in the internal decision making, because that's what within the firm is talking about. Then the more important part of the decision is internal page 199, so page 92 of the authorities bundle. We've highlighted in the margin a longish passage from that page all the way down to D on internal page 201. Could I ask your lordships to read that passage, please?
Sorry, which one from G?
Yes, from G down to D on
On the next page,
the one
yeah.
after.
Yeah.
My lords, I take 4 points from what Mr. Justice McGarry says here. The first is that in distinguishing a partner from an employee at common law, the focus is on whether, in substance, the relationship is one of persons carrying on a business in common, or whether in substance it's a relationship of employer and employee. Second point is that sharing in the profits or contributing to the capital are not prerequisites of partnership status, just indicators. And for our purposes, that of course means that someone could meet one or more of the salaried members' conditions, and yet still be a partner in a traditional partnership. And then, thirdly, it's important to note what the other provisions in the partnership agreement were that persuaded Mr. Justice McGarry that this was a true partnership. And in particular, on page 200, around letter F, there's a finding that neither partner could hire or fire employees, basically, in modern language, and neither partner could borrow or lend on account of the firm without the consent of the other partner. So those are important decision-making functions in this firm, management functions, and clearly those were matters for both of them. There may have been other provisions, we don't know, it's not all there. But those, of course, are not things one expects to agree with one's employee, they're things one expects to agree with a partner. And it's also important to note what's not in this passage, and there's nothing about, for example, billings of Mr. Steekel, the salaried partner, his financial influence. There's nothing about whether he was finding work, nothing about whom he was supervising, junior employees, for example. That's not part of the test that Mr. Justice McGarry is applying, and that courts apply in determining whether someone is a partner or an employee at common law. So that's Steekel and Ellis. I'm going to fast forward now to the introduction of LLPs in 2000 in section 4 of the Act, which is at page 21 of the authorities bundle. The first two subsections, very familiar, just tell us who can be a member. It's anyone who subscribed their name to the original incorporation document.
Sorry, where are you?
Sorry, it's page 21 of the authorities bundle, section 4 of the limited liability.
Yeah.
So subsection 1 is about members who become members on incorporation by subscribing the document, and subsection 2 is about members who become members thereafter by agreement with the other members. Just briefly as well, I should also look at subsection 4, which my Lord Justice Lewison mentioned earlier. Somewhat difficult provision. A member of an LLP shall not be regarded for any purpose as employed by the LLP unless, if he and the other members were partners in a traditional partnership, he would be regarded for that purpose as employed by the partnership. This is a deeming provision for general law. Its effect has been much debated in various authorities I'm going to go to later. I don't think that it matters greatly for our purposes, because I think my Lord, Your Lordship was referring to the deeming for tax purposes that the salaried members rules do.
Yes,
And
I mean, not be regarded for any purpose on the face of it would include purposes of taxation.
I suppose that one would have to say that impliedly the later legislation.
Well, except this is later. That's the problem.
Sorry,
2014 Act comes before the 2000 Act. I'm sorry, you're quite right. Yes,
I think
2014
I'm
comes
right,
later.
aren't I?
Yes, indeed. There might be an implied partial repeal.
I think that must, subject to any instructions I get on that point, I think that must be right. Exactly, it's more specific, as my learned friend says, and so it must politely override.
Yeah.
For tax matters. The tax matters it relates to.
But I think Mr. Vallet said that Mr. Justice Warren already decided this.
If I may, I'll come to Mr. Warren's
Right.
decision shortly. Over the page then at section 5 of the Act, about the relationship of the members, this says in short that the mutual rights and duties, familiar phrase already, the members and the LLP, between themselves as members and with the LLP, are to be governed A, by agreement between the members, or between the LLP and its members, or B, absent agreement as to any matter, by the default rules. And those default rules are over the page, regulations 7.
So, would you accept that when we find the expression mutual rights and duties of the members of a limited liability partnership in section 863C, it's to be interpreted in the same manner as in section 5 of this Act?
It's clearly referring back to it. So, whether it can be interpreted in exactly the same way depends on the exact context in which one finds it. But yes, in essence, the reference is clearly a textual interreference between the two provisions.
When you set up an LLP, the legislation seems to presuppose that there is an incorporation document.
Yeah.
So does that mean that you can't have an LLP by oral agreement? You've got to have some sort of written document?
Yes, I think that's right. To get there, because it has to be submitted to the Register of Companies in order to get the LLP registered. For those purposes, yes.
So in section 5, subject to the possibility of later variation, the mutual rights and duties of the members are those in the incorporation document.
At the moment, it's incorporated, yes, and it's subject to the possibility, I suppose, that it might be a collateral contract.
Yeah.
So then Regulation 7 of the LP regulations, page 22 of the Upper Tribunal. Again, in the chapeau there's reference to the mutual rights and duties, and then it sets out the various default rules that apply. The ones to note here particularly.
This has been excluded.
This has been excluded here, yes, but still, I would say, important context for understanding condition B. So number 1 is equal sharing in capital and profits. Then number 3 is particularly relevant here. Every member may take part in the management of the LLP. And then my Lord Sir Launcelot Henderson referred to 7 earlier. The books and records are to be made available for inspection. Any member may, when he thinks fit, have access to and inspect any copy, etc. Not only is that being excluded, as my own friend pointed out, the only documents the members can see are those that they need to compile their own tax returns.
And that obviously is quite a significant point, because to play a real meaningful part in the wider affairs of the partnership, I mean, how on earth can you do that if you have no right to see any relevant documents?
Exactly so. So the starting point under the default rules is that everyone can play a part in the management. Here, as my learned friend has said, it's the board, 2 people, that has all the powers under the LLP agreement, other than those powers that can only be exercised at a meeting, namely to change the nature of the business, and some borrowing rights, etc. But then, as my friend also pointed out, even at a meeting, the corporate member has a majority vote.
Can I come back to what you were saying the relevance of this is? Because, as we've just been discussing, this is in terms excluded. But I think what you were saying was that this sheds light on the interpretation of mutual rights and duties, not in the sense that we look to this to find out specifically what the mutual rights and duties are, because, as we've just discussed, these are actually excluded. But it sheds light on the concept. Is that what you're saying?
It's actually a slightly wider point. It sheds light also on the rest of condition B, and in particular, significant influence over the affairs of the partnership. Because if one's thinking about influence that the legislation says is given by mutual rights and duties, what sort of influence is given by the default rules so the sorts of things that one typically finds in an LLP agreement are things like voting rights, and similarly, those are things that, if the LLP agreement doesn't provide for them, are provided for by the default rules and give equal rights to the members. And so, looking at those, that's the sort of thing that condition B seems to have in mind when it's talking about influence over the affairs of the partnership. There's nothing in the default rules, for example, again, about financial influence, about how much you bill. There's nothing about any duty to supervise junior employees or any duty to go out and find work. So it would be surprising if, against that background, having used the phrase mutual rights and duties, the drafter, when thinking about significant influence over the affairs of the partnership, was then thinking about how much do you bill, for example. Turning from the legislation, the first case after the enactment of the LLP Act that deals with salaried partners in a broad sense is Tiffin and Leicester Aldridge. Decision of this court, that's at page, starts at page 111 of the authorities bundle.
10.
Sorry.
I'm having trouble hearing you. What are we?
I'm so sorry. Tab 31, page 111.
31.
It's
Yes.
161, but never mind. It is tab
I do
31.
apologise. This was a case about whether Mr. Tiffin, who was described as a fixed share partner in an LLP agreement, a solicitor's LLP, whether he was an employee and had employment rights or not. It's helpful for the purposes of this appeal because, as a result of Section 4.4, what Lord Justice Reimer goes on to do is to consider, if this had been a traditional partnership, would Mr. Tiffin have been a partner or an employee? So the same issue is considered in Sequel. The key passage for our purposes is paragraph 63 to 4, which is at page 184. If I could ask your lordships to read those two paragraphs, and just to explain, Mr. Catherwood is counsel for Mr. Tiffin. So, in other words, a person may be a partner even if the partnership agreement doesn't give them a right to play a significant part in management, but the assumption of such a role may be a strong indication of that status. And again, at risk of repeating myself, the issue here isn't about things like billings or anything like that. It's about management rights, amongst other things.
And I think Tiffin and Leicester Aldridge was referred to either in the consultation paper or one of the ones that followed it.
It's cited, I think, in the consultation paper. Yes.
I think we'll find it's also referred to by Lady Hale, isn't it? In
It is indeed.
case
It is indeed.
coming to it very shortly.
Yes. The next case, indeed, is Bates van Winklehoff and Clyde and Co. I'm going to start with the Court of Appeal's decision, which is actually the previous tab, tab 30. It's decided in the same year, but decided after Tiffin. This was a case about whether an LLP member had the whistleblowing rights of a worker under the Limb B worker status in the Employment Rights Act of 1996, but not about whether she was a partner or an employee. The Court of Appeal held that she didn't have worker status, but that was reversed by the Supreme Court. But in Lord Justice Elias's judgment, there's a helpful passage at paragraph 64, which is page 152 of the bundle. If I could ask, in fact, it's citing our skeleton, so I probably didn't need to ask your lordship to read it. But in essence, what he's saying is that employment's a relationship of hierarchy, subordination, control, however one wants to put it, whereas partnership is a relationship of joint venture, which of course is similar to Mr. Justice McGarry's view that partnership is about carrying on a business in common, and that's the distinction between that and employment. And again, it's important this for understanding what's meant by condition B, because condition B, we say, is about the sort of influence one might expect a partner in a joint venture with someone else to have, and not the sort of influence that one might expect an employee in a subordinate position to have. Then tab 32 of the bundle is the Supreme Court's decision in the same case. We don't rely on this particularly, but I just wanted to go to it to show that it doesn't negate what Lord Justice Elias is saying there. There's some more discussion of, in Baroness to what section 4.4 means. Just purely for context, she says that Lord Justice Ryan's interpretation of it wasn't quite right, because one can have a Scottish partnership, perhaps, where someone can be an employee of that partnership. I didn't think that's important for the purposes of this appeal, but just by context.
Perhaps we ought to see what she says in paragraph 39 about
exactly.
the subordination. Sorry, you're right to go there. Yep.
So page 197. Yes, if I could ask your lordships to read that paragraph.
To what extent is all this affected by subsequent case law as to who counts as a worker for the purposes of employment protections? Because, as has become increasingly clear, the concept of worker is not coextensive with the concept of employee. On the contrary, it extends beyond someone who is an employee.
I do think that it matters for this appeal, because worker status, of course, is not something that condition B is concerned with.
Well, indeed. But that's why I asked the question, because one's got to be a little bit careful for that very reason about direct dicta, which are all about worker status, as opposed to distinguishing between partners and employees. Because the problem is that a worker isn't restricted to an employee.
I entirely accept that and agree, my lord, yes.
Yeah.
In fact, what I was about to say about this paragraph is that I don't see Baroness Hale as saying that subordination isn't part of the employment relationship. And of course, subsequent cases such as Uber continue to refer to subordination. All she's saying is that subordination isn't a necessary ingredient of worker status. And so exactly as my Lord Justice Arnold says, one has to be careful about where we're talking about a worker and where we're talking about an employee. So subordination, control, hierarchy, however one wants to put it, are things that are associated with contracts of employment, whereas worker status, I entirely agree and accept, is something much broader, and I didn't need to worry about worker status. So that Bates, then the final case in this sequence is Reinhardt and Ondra, which is tab 33, so the next tab in the bundle. Rather a long decision, or rather two decisions, I'm afraid. But just to pick out, well, in essence what it's about is whether Mr. Reinhardt had been admitted as a member of an LLP, and if he had been, whether he also had employment rights as a member. One of the issues between the parties was whether on that section 4.4 statutory hypothesis, Mr. Reinhardt would have been an employee if the firm had been a traditional partnership. So again, that opens up the Steeple and Ellis line of case law. This dealt with paragraph 45 of the first judgment, page 218 of the bundle.
Page
218.
218. Yeah.
If I ask you to read from the little letter E to the end of that paragraph.
Yeah.
And so again, the fact that he would have been entitled to play part in the management of the business with other factors was more than a powerful indicator that he would have been a partner had it been a traditional partnership. So again, it's about the right to manage, and again, it's not about how much Mr. Reinhardt was making for Ondra, a financial services firm. It's not about whether he was supervising people or anything like that. So just briefly to summarise what I say we can take from partnership law background is that the conditions A to C don't replicate the common law test, but they do inform how conditions should be interpreted. One sees that from pre-legislative material Mr. Fowler referred to. Specifically with reference to condition B, I say that's derived from the element of the common law test that's concerned with participation in the management of the firm's affairs. And so those words, significant influence over the affairs of the partnership, should be construed in light of that common law context and statutory purpose. And then also, more or less the point that my Lord Justice Arnold was making, the reference back to mutual rights and duties is therefore it would be surprising if condition B was concerned with matters not found in the default rules and not commonly found in LLP agreements, such as financial influence or the supposed typical activities of a partner in a professional services firm. Better construction is that it's concerned with management of the affairs of the partnership at a high level or strategic level. So unless I can assist your lordships further, I'll hand over to Mr. Boots to condition A.
Thank you very much, Mr. Kirby. Yes, Ms. Poots.
Thank you.
Just remind me, what's your remit in this appeal?
My remit is condition A.
Condition A.
Now, as Mr. Blass has already outlined, condition A is the point that the respondents raise in their respondents' notice, and they've set out their arguments in their appeal skeleton.
So, to be clear, you're preempting the cross appeal here. Aren't you?
Exactly. So where I was going with this,
respondent's notice.
it's not the cross appeal exactly,
Yeah,
it's the
respondent's
respondent's
notice. Yeah.
So my proposal was that I would go, as it were, very light and short on condition A and sort of maybe introduce the arguments at the moment, and then spend longer on it in reply if there is more that
Yeah.
your lordships would like to hear.
So the main meat is going to be in reply.
Yes, exactly. It's just a function of the way that the appeals are fought out, as it were, that unfortunately we do have these two big issues in the appeal rather than in the cross appeal.
Right.
Our arguments on this are set out in our supplementary skeleton argument, which is the one that starts at page 83 in the core bundle. And the first thing to note, which my learned friend Mr. Vlatt has already covered, but just as a reminder, is the scope of the arguments on condition A. So before the First Tier Tribunal and the Upper Tribunal, the arguments on condition A covered all of the individual members. For this tribunal, the scope of the arguments only covers the 100 million plus portfolio members plus the desk heads, and none of the other members are brought into the argument at all. We've set all of that in detail in terms of procedurally and where you can find that in our skeleton argument at paragraph 3. I will try to remember to refer them to the members who are within the scope of this as the relevant members, just for the purposes of this. The basic facts on the distributions, what I would propose to do is take you through the basic facts, but also have a look at the LLP agreement, since I think your lordships indicated you were interested in looking at that. The basic facts we could perhaps find most easily in the first tier's decision at, so this is core bundle 198, and it's paragraphs 46 down, 46 and then over on page 247. And what we see there is that we've got three categories of allocation. We're only interested in one of them. The first category is priority distributions, which can be described, and the FTT found this, the first tier found this, can be described as the member's fixed salary. So, for example, we had two portfolio managers who had a fixed priority distribution of 150,000 per year. Those are made in accordance with a letter of allocation, which sets out exactly what that priority distribution is. Those are fixed, so it's common ground that they are disguised salary. Discretionary allocations, which is the category we are interested in, is the category which can be described as the member's bonus. And I say that both because the First Tier Tribunal said that, but also because the traders called it their bonus. And I'll come to the LLP provisions that cover all of those. And then the third category is income point allocations. Now, those income point allocations did not represent a significant amount of any individual member's remuneration. And that was because, we can find this in the First Tier Tribunal at 47, the vast majority of the income points were allocated to one of the corporate members, which was described as the conduit for sweeping up the residual profit and paying it up the group to the fund's participators, including Mr. Platt and Mr. Dodd. Now, the LLP agreement, this is on clause 10. I made the mistake of having notes both on paper and laptop. I'm just trying to make enough space to get those in front of me. The supplementary bundle, and it is page 37.
Page 67.
37.
37.
In fact, I ought to start a little
Right.
higher than that. Let's start on page 36, right at the bottom. So, at clause 10.1, we see that the board is responsible for making sure that accounts are drawn up. and then 10.2, this is an amended version of the LLP, so some of the clauses are a little difficult to follow just because of the redlining, as it were. But 10.2 is the board shall, following the end of each financial year, and then if we jump to the end of that, by reference to the partnership accounts drawn up, determine the allocation of the profits and losses amongst the members in accordance with the clauses, with provisions for clauses 10.3, 4 and 6. Then we get the then we go to 10.3 for how those allocations work. That's still on page 37. 10.3A1A or 10.3A1A is profits to cover expenses of one of the corporate members, and B is retained profit effectively. We don't need to look at either of those in any detail. It's 10.3A2 that is relevant. So 10.3A2 is the allocation of those priority distributions. That's the fixed amounts. 10.3A3 is the discretionary amounts. There is a complicated calculation there we don't need to go into. That's just imposing a limit on those profits, but it's allocated to such of the members, if any, as the board shall, in its absolute discretion, determine, and it's broadly the profits left over after the priority distributions. And then we go down to page 39. We find the income points at sub 4. So the remaining profits shall then be allocated amongst the members in the agreed income proportions at the relevant time. So priority distributions come out first, then the board has its discretion over discretionary allocations, and then anything else goes on income points. That effectively goes to the corporate members, not to the individuals. And just to give you an example of what actually happened, I appreciate this, we'll come on to this as a look forward test, but to give you an example of what actually happened, if we look in the first decision at paragraph 57, I'll just find the page number, that's 201.
In which bundle?
Core bundle, 201. This is a table covering all of the relevant years, the years in dispute. We see the total profit in the first column after the years. Then we see the total allocations. And then we can see how those were divided up between individual members. I'll come back to PIP facilitators, but I'm aware that some of your lordships will be very familiar with that. So we can see everything going to the individuals, and then we can see that there's in each year something, as it were, left over that goes to the corporate member. The PIP facilitators, that's the partnership incentivisation plan, which for the purposes of this appeal, thankfully, we do not need to address, but it is agreed that those are treated as allocations to the individuals. So we can just treat them in the same way as the other allocations to individuals. The process, so that's the categories of allocations. The process for determining discretionary allocations is set out. We're only looking at the portfolio managers and desk heads, so we can go to First Tier Tribunal at 58, so it's immediately below that table. And I'm aware that your lordships have read these decisions, so I'll just skip through it swiftly. Broadly, what they were doing for the portfolio managers was calculating the profit or loss on that portfolio manager's own capital allocation, so the amount of capital that they were allowed to put on risk, applying a headline percentage to that. So just to give you an indication, for a lot of the period, the percentage was 18%, and then taking away costs. So the the discretionary allocations are calculated entirely on the basis of the individual portfolio manager's performance, not the overall profits of the LLP. And there's a helpful example of the results of that on Mr. Moore and Mr. Wilson, the two of the witnesses, and some of their detailed figures were looked at. This is on page 202 at 65 and 66. And what we see is that in some years they get no discretionary allocation, even though the LLP profits have increased because their portfolio didn't do well that year. And in other years, they make a good profit on their personal portfolio, so they get a good bonus, but the LLP profits have fallen in that year. We don't, I think, need to look at the variable, to look at the document that sets out the method, but there was a document setting out the method. This was a formal method, and it's in our supplementary bundle at page 71 for your note. That is, I think, all I was going to cover on the facts, unless your lordships have any questions on those. You've seen the legislation for condition A, but it might be helpful just to have it open as we go on to how it should be interpreted and applied. It's in the authorities bundle at page 43. And I've described it as, indeed, I think everyone agrees, and the tribunals have described it as this, a look-forward test. One is looking at the position at the beginning of each relevant period. The first relevant period that we're looking at starts with the beginning of the tax year 14-15, when the legislation was introduced, unless one joins later during that tax year. And then one looks at each accounting period, at the beginning of each accounting period, to apply the test. All of that's explained in our skeleton at 14. I'm happy to go into any detail, but for present purposes, it's not understood to be disputed, or at least it's not understood to be an issue. If that turns out to be wrong, I shall of course come back to it in reply. But that was the conclusion of the first tier and the upper tribunal. So that's the relevant periods. It's step 2 that we are interested in, over onto page 44, as to when condition A is met. And the key words we're looking at here are condition A is met if it is reasonable to expect that at least 80% of the total amount payable will be disguised salary, and an amount is disguised salary if it is A, fixed. We're not interested in fixed because these aren't fixed amounts. B, variable, but varied without reference to the overall profits or losses of the LLP. Or C, it is not in practice affected by the overall amount of those profits or losses. There's limbs B and C that we are focusing on here. Now, the First Tier Tribunal found, and the Upper Tribunal upheld, that the portfolio manager's discretionary allocations varied by reference to their individual performance, that calculation I've just talked you through on their portfolios, and that there was no evidence that the board took into account overall profits. And so, get this the right way around, those tribunals found that condition A was met in relation to all of the members, but in particular to the relevant members we're talking about now. For this court to identify what the issue is now, and indeed it was the same before the Upper Tribunal, BlueCrest's case rests on the fact that there was a cap on discretionary allocations. So those discretionary allocations were limited by reference to the total profits of the LLP. And BlueCrest say well, there were times when we faced real financial risks, and in light of those financial risks, there was a real risk that discretionary allocations would be affected by the cap.
And that cap, that comes from 10.3, is it? Because the discretionary bonuses should not exceed the lower of two amounts, which I have to confess I have not got my head around.
No,
is that where the cap comes from?
I'm not sure it's worth doing so. The cap comes from, the First Tier Tribunal described it as both a contractual link and a practical link. I can show you the findings on that. It might perhaps be easier if I find it in the Upper Tribunal because they summarise.
Is this one sort of paras 149?
Oh, thank you. Yes, is that, but there's also a reference to clause 10.8, which I'm just failing to find. If I might just find it in the Upper Tribunal decision, I can come back to the first tiers. Yes, it says in the Upper Tribunal at 147, that refers back to 146. Sorry, not 146. 152 in the First Tier Tribunal.
Yeah.
So yes, it's 151 and 152. The contractual provision identified by the Upper Tribunal is 10.8, which is a provision about drawings in advance, so discretionary drawings which the LLP has the right to require to be repaid if the profit proves to be insufficient. We also have, I think, a fairly neat finding in the FTT's, the First Tier Tribunal's analysis on the condition A. So paragraph 166 of the First Tier Tribunal, so page 230, they talk about a document called the April 2014 resolution, which was intended to formalise the cap. We're ignoring
But for
that
your
resolution.
purposes, you only need to show that one of the limbs of condition A is applicable. The FTT has found that two limbs are applicable.
Yes, quite. Quite. And I suppose I'm going to the cap because that is now the only thing that the BlueCrest relies on. So previously there have been a wider discussion about how the allocations worked, but now we are focusing purely on the cap. And so there are broadly two issues on limb B, and actually they're quite neatly encapsulated by the Upper Tribunal at paragraph 150, page 158, where it's divided into two issues, but I can put them shortly. The first issue is the question of interpretation. So the question being whether a cap of the type I've described, a cap by reference to total profits, is a sufficient link to show that the allocations are variable by reference to overall profits. We're focusing on the word variable there. Both the First Tier Tribunal and the Upper Tribunal found that as a matter of interpretation, a cap by reference to total profits was not a sufficient link to make out that the remuneration is varied with reference to overall profits and losses. That's the first issue on limb B. The second issue, if, contrary to what I've just said, what the First Tier Tribunal found, the Upper Tribunal found, and what we argue, if a cap is a sufficient link, was it relevant on the facts here? In particular, was it reasonable to expect that the cap would apply? So those are the words in the opening provision to step 2 of condition A. Was it reasonable to expect that the cap would apply? And there, both the First Tier and the Upper Tribunal found that that BlueCrest failed on the facts here. And in particular, BlueCrest was relying on these real financial risks or real commercial risks, but the First Tier Tribunal concluded that those didn't appear to have affected the board's attitude towards this variable remuneration at all. That's in the First Tier at 143, which is page 156. No, sorry, it's not page 156, 143, page 225. So the First Tier accepts that there were times when the appellant had faced, the taxpayer had faced significant financial risks, but they do not appear to have affected the attitude of the appellant towards variable remuneration. It goes on to give 2 examples, one of which is something that could have been known in advance of the period, so the outcome of this appeal, and the other, sorry, not that the outcome could have been known, but the risk was known, and the other being the COVID pandemic, which wouldn't have been known before certain accounting periods began. So the First Tier expressly found that. The Upper Tribunal also noted that BlueCrest hadn't met the burden of proof in demonstrating that it was reasonable to expect that discretionary allocations would be affected by a reduction in profits or incurring of losses. So that's the decisions on condition A. I'll just outline HMRC's position, which is fairly straightforward in that it's the both tribunals got it right. And then, as I say, I'll come back to anything further in reply. On the interpretation argument, HMRC's position is set out in our supplementary skeleton at paragraph 18. I won't go through these in huge detail, but in broad terms, HMRC's position is that the tribunal were correct to interpret condition A in accordance with the purpose of the legislation, which my learned friends have covered already, and to note that in a typical partnership, profits are allocated by reference to overall profits, and by contrast, an employee might receive a bonus based on their own performance. And the discretionary allocations made by BlueCrest followed that second approach, more similar to an employee. The imposition of a cap by reference to profits doesn't change the nature of that remuneration mechanism. And in particular, if one were to interpret Lim B as allowing such a cap to have the effect that the amount is varied with reference to overall profits, that would be inconsistent with the purpose of the legislation. The cap is merely reflecting an obvious limitation on distributing actual profits, and in particular it has no effect on the partners enjoying the upside of a good year. So that's the interpretation on B. Turning to C on interpretation, Lim C, the question there is whether it is reasonable to expect that profits would be affected by, that remuneration would be affected by an insufficiency of profits or even by losses. Now, we say one needs to look at the beginning of each year to understand what the reasonable expectations are, and if it is only if one can demonstrate a reasonable expectation that the profits are not going to be enough to meet the proposed allocations that one can fulfil the reasonable expectation test. Now, by contrast, BlueCrest's interpretation appears to look just at possibilities or risks. So the existence of any commercial risk would make it reasonable to expect that the profits wouldn't be sufficient, and so the remuneration would be affected. And we say that approach just too generous, doesn't give effect to that phrase reasonable expectation at all. It is, of course, the case that almost any trading LLP would have commercial risk that might affect profits, and and one can't simply say, well, there are risks, so they might not be able to pay out what they want to. Then on
So
the
just going back to the words
yes,
of condition A, which you've helpfully set out at paragraph 8 of this skeleton, you say that if you read limb C into the overall rubric, that condition A is met if at the beginning of the year it is reasonable to expect that at least 80% of the total amount payable by the LLP would not in practice be affected by the overall amount of the LLP's overall losses or profits or losses.
yes, exactly.
And so it's by relying on the words in practice, is it, that you
Yes,
say
it's
that
both.
the prospect of a perceived risk eventuating, judged as at the beginning of the year, is something that must be taken into account.
Yes, it's both in practice, but also reasonable to expect. It's both of those words, those phrases together that give you that answer. There might be other examples where you can just get there by in practice because the cap, whichever way it works, is set so sky high that it's just, you don't even need to go into reasonable expectations. But in general, one needs to consider both reasonable expectations and what will happen in practice in accordance with those reasonable expectations.
Yeah.
So that's interpretation, and as Lordship has rightly noted, we only need to show that these discretionary allocations meet one of B or C to show that condition A is met. On facts, our position on that is set out in our supplementary skeleton at 20 and 24, effectively summarising what the First Tier Tribunal has said, and as Mr. Blatt said, in order to overcome the application of these tests to the facts, the BlueCrest needs to dislodge the First Tier's findings of facts on how this process worked. I've already briefly taken you through those conclusions, but just as a reminder, the First Tier accepted that BlueCrest faced financial risks, but concluded that those did not appear to have affected the board's attitude towards variable remuneration. And the Upper Tribunal noted, this is yes, it's 156 in the Upper Tribunal's decision, which is on page 159. So the Upper Tribunal noted that BlueCrest had not met the burden of proof in demonstrating that it was reasonable to expect that the discretionary allocations would be affected by a reduction in profits or by incurring losses. And it is perhaps just helpful to reinforce that BlueCrest has not advanced any case or any evidence that at the beginning of each accounting period there was any expectation of very low profits or even losses, let alone that a reasonable expectation of those low profits or losses. So the most that BlueCrest has ever said is that there was a real risk of these sorts of financial risks impacting profits or losses. So our broad point is that both tribunals got it right on the facts as well as the interpretation, and so ultimately they were correct to hold that the relevant members met condition A. Our skeleton argument covers the procedural position on the anti-avoidance argument, but I needn't go there because it's simply not in dispute. I had nothing further unless your lordships had any questions.
Thank you very much.
Thank you.
Yes, Mr. Blatt.
Grateful. If we're going to look at condition B and influence, if we go back to the
Microphone, please, sir. Microphone, please, sir. Thank you.
Yeah, microphone in the bagging area. So, we go back to the technical note, just to pick up what it says about influence. And if we could look at it's page 723, bundle page 723.
723.
723 in the authorities bundle.
To what extent are we entitled to rely on this technical note in order to interpret the legislation, as opposed to discern its broad policy objectives?
My submission is that it's for policy objectives. At least for present purposes, it might be different in the admin court, but this is informing. This is part of the background, part of the context, and I don't think anything different flows from the Supreme Court's decision in Cobalt Data Center on that. I don't think that intends to change radically. It's just an example of looking at other factors to see the purpose, and then obviously one needs to look at the language and interpret it to give effect to that purpose so far as possible. In Cobalt, they were starting with two possible interpretations, and here we're not going to say anything.
Yeah.
So these aren't, as it were, strong points in that I say that one can discern the purpose of the legislation from the legislation, which is the best place to look. But there's some support, and I think it's right to draw the court's attention to it in the guidance. So if we go to 723 in the bundle, this is not all of condition B. That starts at 7. Well, maybe we should start at 722, which is setting out condition B.
Yeah, where they say the question to ask whether the individual has a significant influence over the activities of the LLP as a whole.
Yes. Yes. Which we say is what we're asking for, unsurprisingly. 251, the significance of size. Just picking up that condition B is likely to be particularly important for members of smaller LLPs. We say that ties into the point I was making earlier, that if one has a lot of members, necessarily each member's influence will be reduced. And to the bottom of 723, we looked at the examples. It's unlikely that this condition will exclude many members of very large partnerships, since in such cases it's likely that only a minority of individuals have significant influence over the affairs of the whole partnership. There's no line in the sand as to the number of members who can exist consistent with all of them having significant influence, etc., etc. I mean, the revenue can't win simply by publishing guidance that supports its case. We're not saying that. There's also at 252, just going to pick up what types of influence. The purpose of condition B is to exclude from being salaried members those individuals who have a real say in the business. Test is applied on the basis of a realistic view of the facts. So this is, it's consistent with this, that our primary case is slightly broader than looking at the purely, as it were, black letter mutual rights and obligations. And after I've read this, I'll just come on to a look at the way we've put it in the skeleton and suggest, if I may, a refinement of that. So 252, that was the first paragraph. Second paragraph, look at the agreements, the LLP agreement, any contracts between the firm and its investors, the agreement includes not only the written agreement but also verbal or implied agreements. I mean, noting that in order to have an agreement that affects the membership as a whole, or the members as a whole have to sign up to it, I don't think that would be an insurmountable difficulty for the LLP in this case. I think they might be able to argue, if they wanted to, that the membership all knew how things worked and so on and so forth. They haven't made that argument, but I'm not saying it's impossible for them. And then this is the bit just to run through. The following are examples of the kind of decisions which might be involved in appropriate cases, not intended to be prescriptive or definitive, and it's not necessary that the same people are involved in all the decisions, nor would having significant or even controlling influence over just one of them necessarily mean that the member has significant influence over the firm as a whole. And then we've got a list of what we say are clearly high-level decisions. Appointment of new partners, where the firm conducts its business, areas of strategic decisions, business acquisitions or disposals, management of key contracts, appointment of key personnel, allocation of roles to key staff, decisions on important financial commitments, formulating the business plan, approving major new clients, particularly where there's a regulatory requirement, and deciding the marketing strategy. So we say these are high-level type decisions rather than day-to-day decisions. And then, as noted above, members of the board or management committee of a large professional firm are likely to have the requisite level of influence. By contrast, it says underneath, merely being able to vote or express a view on such matters would be unlikely in itself to constitute significant influence. Sometimes, an individual who has no apparent role in the management of the business may wield considerable influence. If, on a realistic view of the facts, the members defer to the views of that individual, then the individual can fail. Condition B. So it's in line with that guidance that we're putting our case as we have, that it encompasses effectively a shadow director, a partnership with the sort of influence a shadow director would have. Now,
how does that fit with the point that Sir Launcelot raised, namely that we're looking at mutual rights and duties?
Well,
all this says is if, on the facts, the members defer to the views of the individual can fail condition B.
Yes.
Where are the rights and duties in that formulation?
I accept that the way we've... Sorry, I've just lost the skeleton. Yes, I accept that a very broad and wholly, as it were, practical or de facto approach does move quite a long way away from legal mutual rights and obligations derived from the partnership agreement. And the way we put it in the skeleton...
Presumably this last paragraph is to be read together with the second paragraph about the sources of the mutual rights and duties, and explain there that the sources will be the written agreement and may extend beyond the written agreement to oral or implied agreements. You've still got to have some source of mutual rights and duties.
If I may, what I was going to say, in our skeleton at paragraph 21, we've said we accept that it's permissible to look beyond the LLP agreement and consider actual or de facto influence. That's reflecting that last guidance. Our paragraph 51 does need to be read against our paragraph 50, which says that the agreements are the starting point, the first source for it. I would say if we've gone too far in the skeleton, then what we're... perhaps this is a better way of putting it, that our primary argument is that the court can look at the mutual rights and obligations, or rights and duties, derived from the LLP agreement and any other relevant agreements as operated in practice. Alternatively, and this would be probably a slight hardening of the line, our secondary argument would be that one can look at the LLP agreement, etc., but one looks at the LLP agreement, etc., but in doing so, ignore any provisions that are not intended to take effect. That's to rule out the possibility that people try and draft themselves out of,
Well, I mean, if some parts of an agreement are a sham, then of course you don't have regard to them.
Yes, but whether it's yeah, yes. Again, maybe that is a statement of the obvious, but we're trying. The revenue is trying to take a practical approach to the operation of this rule, and to recognise that sometimes merely looking at the black letter of the agreement doesn't properly reflect what happens on the ground either way.
Well, and there are many contexts where I would be completely in agreement with that, because it's normally a very sound principle to look at what happens on the ground, as well as at the black letter of what the parties have actually signed up to. The problem here is just the constraining effect of the way that Condition B is actually worded.
Well, as I say, maybe we've gone too far in our skeleton in trying to give effect to a realistic view of the facts. We certainly accept that the starting point for this are the mutual rights and obligations found in the LLP agreement. Those at the very least tell you what sort of rights and obligations, and therefore what sort of influence one's interested in. We would say where you can see from the LLP agreement, both as written and as operated, that the person has those sorts of rights and obligations, then in a sense that's an easy decision.
Yeah.
As one moves away from that, whether that's to the person who, without apparent rights and obligations, nonetheless in practice wields the rights and possibly observes the obligations, well, that's a harder case. But that doesn't actually matter for present purposes in a sense, because we're not concerned with Mr. Platt's status, for example.
Well, do you want to have a bit more of a think about it for the next hour or so?
I'll keep thinking. I had instructions that was an adequate formulation from our point of view, but we'll keep going. On timing, I hope I'll be finished within an hour, although that's obviously subject to the points that your lordships find interesting, but maybe that's for my and the friends' benefit.
All right, 2 o'clock.